Hello, good afternoon, class. Today we're going to talk about stop and frisk. We've moved on to chapter 4. Of course, I'm here with family vacationing, so may get the occasional interruption, but we're going to go ahead and work through this. I have some helpers that may want to help give this lecture, but stop and frisk. So, as an introduction, in Terry v. Ohio, very important case, groundbreaking case, probably the case. This led to more police and citizen interaction than any other case. And I would say it might be the deadliest case because, of course, the more police interaction you get, the higher the likelihood that uh, uh, the higher the likelihood of a police incident where there may be use of force. But in Terry v. Ohio, and that's we call it the Terry case. In Terry v. Ohio, the Supreme Court held that the Fourth Amendment reasonableness clause should be interpreted to provide for police stops and frisk without warrants or probable cause. The court held that stops and frisk under the Fourth Amendment reasonableness clause are based on an objective weighing and balancing of the interest in crime detection and investigation against a limited intrusion on individual liberty. So we talked a few chapters ago at the beginning about what we're always balancing, and we're always balancing um, the interest of crime detection and safety versus our individual liberty. So the rationale of the court in the Terry case was essentially that, well, since it's just a stop and frisk and it's not an invasive search, then we'll say that there's not the interest of personal freedoms isn't really impeded upon. So we'll go ahead and kind of see it as though there's more of an interest in a stop and frisk and crime detection, and we'll go ahead and put that above uh, personal freedoms because it's only a stop and frisk. It's not supposed to be for a long period of time, or it's just us talking to you or patting you down to make sure you don't have anything. So that's not really a search. So we'll allow that to be constitutional. So these stops are distinguished from custodial arrests by their narrow investigative purpose and limited intrusion on individual liberty, and therefore may be based on the lesser standard of reasonable suspicion. So it's no longer about probable cause with Terry stops; it's about reasonable suspicion. So reasonable suspicion is a lower standard than probable cause. So um, the Terry case took an additional step of holding that officers are entitled to conduct frisk to protect themselves in those instances in which they possess reasonable grounds to believe that the suspect is armed and presently dangerous. So that's why we call them stop and frisk. So it's just not a stop where we can stop and talk to you or ask you a question or two, or ask you if you saw someone run past you or which direction they went in. But we can also stop you, question you, and because we feel like there may be a concern for our safety, we'll pat you down just to make sure we're safe. So that kind of opens up Pandora's box because what happens, as I told you before, with law enforcement, and we talked about circumvention of the rules. They're always going to create a rationale or a way to get around the rule or to do more. So if you give them a rope, they're going to take. They're going to want to be a cowboy. If you give them an inch, they're going to want to take a mile. So, of course, with this stop and frisk case, I believe the court was well intentioned, but they didn't think of the fact that law enforcement was going to take it to the next level. But we'll get to that. The reasonable suspicion. The police officer, in justifying the intrusion, must present specific, articulable facts that, together with rational inferences drawn from those facts, reasonably suggest that an individual has committed a crime or is about to commit a crime. This is an objective test. Remember, objective meaning reasonable person, that standard person. So it is a objective test, and the facts are to be evaluated based on the totality of the circumstances in light of the officer's experience. So when we talk about in light of the officer's experience, what's that sound like? It's also subjective. So it's a little bit of objective and there's a little bit of subjective because we have to take into account that officer's experience. So in making the objective judgment, we also have to take into account that officer's subjective level of experience. The Supreme Court has recognized that articulating what reasonable suspicion means is not possible It is a fluid concept, and that's scary, but I'll get back to that. That must be evaluated in a particular context. Several factors, in combination with other factors, have been held to be relevant to the determination of reasonable suspicion. These include a pattern of activity indicative of criminal conduct, the time of day, whether the suspect is observed in a high crime area and is known by a police officer to have criminal record, whether the suspect is nervous or uncooperative or flees from the police, and whether the police officer has experience in making arrests for this type of activity. Now, back to what they're talking about with the Supreme Court stating that recognizing that let me see, reasonable suspicion is a fluid concept, is not really defined. That that's another thing about probable cause. None of these standards are actually defined. You can go to 8 different textbooks and they'll each have a different definition of what probable cause was, and the Supreme Court doesn't really tell us exactly what probable cause is. Same thing with reasonable suspicion. So what the Terry case now created was a situation where police officers can interact with you involuntary. Well, not at your volition. Essentially, they can choose to talk to you and stop you in your tracks and interrupt whatever you're doing to have a conversation with you or ask you a question based upon a standard that isn't really well defined. So they can say, "Well, I have reasonable suspicion," and but because we don't know exactly what reasonable suspicion is, and it's looked at on a case by case basis, that allows them to now stop you, ask you questions, and now because of their safety, we're going to pat you down. What do you think those pat downs turn into? At some point in time, they always go a little bit further. It starts as a pat down. Oh, what's in your pocket? Pull your pockets out. So now they're giving orders and telling you to essentially empty your pockets. So it becomes a search. So, but we'll go further into that because the one thing about law enforcement is a cat and mouse game. So in trying to detect and catch criminals, sometimes law enforcement officers bend the rules, so they almost become criminals themselves. It's like watching the episode of Tom and Jerry. If anyone knows about the old school cartoon Tom and Jerry, Tom was the cat and Jerry was the mouse. So of course a cat chases a mouse, but if you watch it long enough, sometimes you can't tell who's chasing who because there are episodes where Jerry will be the antagonist and he'll be bothering Tom. And he'll make Tom have to chase him because he's done some type of prank or done something to make Tom mad. But that's kind of how it is with the cops. It's a cat and mouse situation where after a while you can't tell who the bad guys are and who the good guys are. So it becomes mixed up. So when we have these standards that aren't really defined, what do you think they're doing with these undefined standards? They're doing what they want to do, and then at the end they say, "Oh, well, we had reasonable suspicion." Well, what is reasonable suspicion? No one defines it. No one can define it. It's on a case by case basis, and depends on if you find yourself arrested and now you're in court, trying to fight these charges against you based upon your rights being violated. It almost becomes luck of the draw. Like, do I have a judge who might be a constitutional purist who sees interactions with cops as having to be well defined. But you may run into a judge that may be pro law enforcement, is cool with everything they do. So it's still kind of up in the air. And we talked about how we want laws to be definite so we can and accurate so we can walk into court and almost be able to predict what happens. But it's hard to do that. So that is the danger in the Terry case. The Terry case kind of opened up Pandora's box, um, especially on a racial level. Where do you think most of these people are getting stopped at? What types of communities? What would be the demographic that you think these communities fit? The black communities. You have in the Terry case is a case out of the 1960s. So what was going on in the 1960s? Essentially, you have a war on drugs, or you have the CIA and the FBI and local and state law enforcement. They're essentially attacking and trying to break down um, certain sectors of certain communities. So in doing that, you have a law enforcement presence. So who do you think the Terry case was meant for? So once you have the Terry case, or not necessarily the case itself, but when this case comes out and they render this judgment, this now gives law enforcement officers fuel to say, you know what, we're in this we're in this majority black community, and we're going to police it how we want to, and we're going to always say it was a Terry stop, always based upon reasonable suspicion. That's why we had to stop this guy and question him, and we ended up roughing him up. So that's what it created. So this is a very, very dangerous case. So informants and hearsay. The judge asked whether the informant is known to the police and how the informant obtained the information. An informant with firsthand knowledge of criminal activity should be able to provide detailed information. A tip that cannot be supported on these grounds may be relied on where corroborated by essential details by the police. Most important is the police determination that the informant was able to predict a suspect's future conduct. The judge strikes a balance. In those instances in which an informant is not known to the police, the court may require that the informant provide detailed information. A tip from an informant who is not known to the police officer may be strengthened by police corroboration as well as by the fact that the informant came forward personally, and that the state criminal statute punishes the intentional false criminal making intentional false criminal reports. So essentially, what that means is that with almost any informant, the cops would probably need to corroborate what the informant is telling them. So that's why they almost have to stake it out and say, "Wow, that the informant told us that they're going to be dropping the package at this location at 5 o'clock. We've been watching it all day, and at 5 o'clock they dropped the package off." So kind of has to be corroborated by facts and by surveillance. So, drug courier profiles. Law enforcement officials have developed profiles to assist in detecting, and investigating individuals who may be engaged in criminal conduct. The first profiles were developed to detect trafficking in illegal narcotics, and we don't like the word profile, right? That means you're kind of guessing who a person is based upon a demographic. Well, all drug dealers do it this way, so this is how they look, this is how they dress. So it kind of creates a situation where cops are making decisions based upon a piece of paper they're looking at, and not based upon looking at the situation. So it's like, well, the guy's dressed in a gray suit. All dope dealers dress in gray suits, so let's arrest him. And that's stupid. Courts generally do not give special weight to the claim that an individual fits a profile, and instead merely ask whether the combination of factors identified in the profile constitutes reasonable suspicion that a suspect is engaged in criminal conduct. So essentially, that gives trial courts a lot of credit that I'm not willing to give them. They're probably getting it wrong, and they're probably letting these officers kind of run roughshod and do what they want to do. But that's my opinion. But just read the book, okay? Uh, race and reasonable suspicion. And I kind of delved into this a few minutes ago. The police may not stop an individual when the only reason for his or her seizure is race, ethnicity, gender, religion, or other protected descriptive characteristic. An individual may not be stopped based on what we call incongruity, or the fact that he or she does not belong in a neighborhood. So, in other words, a black kid moves to an upper middle class neighborhood. He's one of the only there are a handful of black families in the neighborhood, and he's walking around with his fresh gear. He got his Nipsey Hussle shirt on. He got his Crenshaw on, and he's chilling, just walking around the block, chilling out. It's his neighborhood. He just moved there. The cops see him as like, oh, that kid doesn't belong here. Let's stop him and talk to him. That is inherently racist, and that is wrong. Sad thing is, that's what happens. That is exactly what happens. This another sad thing is, this kid probably isn't going to get a whole lot of protection from the court system. I hate to say it. I know I'm in the court system, but judges aren't protecting these kids. Uh, we try to. We can file motions, but these kids you're walking around in a neighborhood that they don't belong in are going to be targets. So it's scary. You see what this Terry case is doing is now essentially giving the cops um, permission to stop people for almost no reason at all. But it now gives them the leeway to kind of create the reason why they're stopping a person. Race, ethnicity, and some other objective characteristic may be considered as one of several factors that together support a finding of reasonable suspicion that crime may be afoot. I wholeheartedly disagree with that. That's in the book. I wholeheartedly disagree with that. But that's essentially what the Terry case is saying. I'm not, as you can tell from from what I've been saying to you, I'm not really cool with the Terry case. I think it was one of the worst things that the Supreme Court did. And it's the reason why a lot of young black kids are getting gunned down by police because cops essentially get to walk up to you and start this interaction. The Terry case kind of took away our ability to be left alone. For one moment. But it took away our ability to be left alone. Hold on. This is my wife. Hey, I'm in the middle of a lecture. Yeah, what's up? Uh, just fish or something for me. Kale and some beans or something like that. Call them and ask them. I'm doing the lecture, babe. All right. All right. Sorry about that. Okay, where was I? The scope and duration of a Terry stop. The Terry stop. So now we're going to talk about exactly what a Terry stop is. So everything we're talking about now is kind of why and what but now we're going to learn exactly what's allowed at a Terry stop, what we call a stop and frisk. A Terry stop and frisk is a limited intrusion to investigate to investigate and to detect crime. It is a basic constitutional premises that law enforcement officers may intervene with an individual's freedom and privacy only to the extent required to accomplish their purpose. A Terry stop is subject to legal challenge in those instances in which the subject is treated as if he or she has been subjected to a probable cause, that's a higher standard, arrest rather than a reasonable suspicion stop. This inquiry typically focuses on three areas. The Terry stop does not permit the involuntary and significant movement of a suspect unless required by reasons of safety and security. A suspect detained on reasonable suspicion generally cannot be removed to the police headquarters. So what that means is Terry stop almost has to be right there. So we're stopping you, we're asking you a few questions, and we're patting you down right there. The minute we now start to move you from that place to another place, that now is now being graduated to a probable cause arrest as opposed to a stop. So this is a full seizure now where you're now taking me into custody. Now, of course, there are exceptions. If we're in the middle of the street and traffic is coming and the cop is trying to talk to you, of course, let's move over to the sidewalk for both of our safety. Yes, that is a movement, but of course, as I said before, that's kind of the safety exception. So of course, we can move out of the middle of the road to talk to you, or have you move over to talk to you and pat you down. So that's what that allows. Okay, a Terry stop must be for a limited duration. A suspect cannot be subjected to a lengthy interrogation. So that means a Terry stop also is not supposed to take all day. So you have a matter of minutes. The law enforcement has a matter of minutes in which to engage you, talk to you, ask you a few questions, of course, pat you down for their safety, usually at the beginning, and talk to you. It's not an arrest. So at some point, you got to say, well, you have a right as a citizen being talked to by the cops and say, hey, I don't want to talk anymore. I was on my way to church to praise the Lord. So holler at your boy and you can walk away. So at the point where they're not going to let you walk away, the question now becomes, is this an arrest? Is this now a reasonable? I mean, is this now a probable cause arrest? And is it now no longer a Terry stop that only requires reasonable suspicion? So, okay, in determining whether the police have carried out the Terry stop and frisk in a reasonable manner, courts inquire whether the investigative methods employed were the least intrusive means reasonably available to verify or dispel the officer's suspicions in a brief period of time. So, in other words, they must be using the least intrusive alternative or means of questioning you. If they want to ask you a few questions, of course, it is intrusive if now they're running your pockets and got you half naked, taking your clothes off, and searching your socks and doing all that crazy stuff on the side of the road. While they're talking to you, or in your neighborhood as you're walking up and down the street. Another thing, what is a frisk? You know what? I'm going to leave that. We're going to get to that next. But let's see. A suspect ordinarily may not be detained by force or threat of force, handcuffed or locked in a patrol car. At that point, when hands are put on you, or when you're cuffed, or when you essentially can't move and come and go or move anymore, that is no longer a Terry stop, and it's no longer just reasonable suspicion that's required. Now they have to actually show that there's probable cause for you to now be detained. So if it was just a stop where they were just going to ask you questions, did you see this or did you see that, and they patted you down, and now this pat down, now you want to leave and you're ready to stop talking, now you can't leave, or they put hands on you, or there's some type of show of force. Remember we talked about certain show of force seizure, where they may not necessarily handcuff you or put you in a car or physically move you, but they're around you in a way that that is indicative of the fact that you can't move. So if I'm surrounded by officers and it's kind of a show of force, got their hands on their guns, I like to leave, but I know if I walk in any direction, I'm going to bump one of them. That essentially means I'm now kind of under arrest. I can't come and go as I please. So sometimes the best question to ask is, "Hey, am I being detained?" or "Hey, am I free to leave?" If they say no, then at that point they got some explaining to do. So if I'm not free to leave, this is an arrest. What have I done? Where's your probable cause? Reasonable suspicion allows you to stop me and question me and ask me a few questions, and you can pat me down. But if I'm not free to leave, now you have there's a higher standard that applies. It has to be based on probable cause. So let's get to what a frisk is. The Supreme Court in Terry v. Ohio recognized that American criminals have a long tradition of armed violence, and that a number of law enforcement officers are killed and wounded each year in the line of duty. The court accordingly ruled that where nothing in the initial stages of the encounter serves to dispel an officer's reasonable fear for his own safety, he is entitled, for the protection of himself and others in the area, to conduct a carefully limited search of the outer clothing of such persons in an attempt to discover weapons which might be used to assault him or other people. So what that means, I said outer clothing. So a frisk does not it's not a frisk if they're actually putting their hands in your pockets or they're asking you to empty your pockets. That's another trick that's used as well. So they can pat the outside of your pockets, but when they say, "Hey, can you empty your pockets?" They're almost making you search yourself. So when they ask you, "Hey, can you empty your pockets?" Say, "Nah, I can't. I don't want to." At that point, they're trying to make you almost search yourself and run your own pockets, because they're not supposed to put their hands in your pockets. Um, I think they're on a porch. Um, but so it's supposed to be a pat down and not an actual intrusion, I'm sorry, into your pockets. So that's what a frisk is. There's anyone that's ever been to the nightclub, when you're trying to get in, of course you got the bouncer up front and he's patting you down, but of course the bouncer up front, he's not serving in a law enforcement capacity. He's trying to make sure nothing gets in the club, right? So he can probably actually run your pockets and say, "Hey, empty those pockets." But a cop that's now encountering you on the street can't just have you run your pockets for no reason. So in 1983, in Michigan v. Long, the Supreme Court extended Terry frisk to the passenger compartment of automobiles in those instances in which a police officer possesses reasonable fear for his or her safety. In Minnesota v. Dickinson, the Supreme Court affirmed the limited right of a police officer conducting a frisk to seize illegal narcotics. The officer must have immediate probable cause to believe that the items he or she encounters are illegal narcotics. Now, there's two weird cases, right? So, if you had, and this is just hypothetical, if you have a napkin, I think I have a paper towel right here, I'm wiping my forehead off with. So, if I ball this up like this, put it in my pocket, see how that looks? How does this feel any different than than a dime bag of marijuana that essentially feels like this in your? So once you put it in your pocket and someone's patting you down, this doesn't feel any different than a dime bag of marijuana. So so if an officer comes up and pats you and says that feels like weed, how does it feel like weed? How does it not feel like this? So it's kind of bull crap. You can't tell what's in something. Now, of course, if someone has a knife in their pocket or a gun, you can almost tell a gun when you feel it. So you can feel the barrel, you can feel the handle. You know you're patting somebody down. They have a gun or a knife. Normally, it's a blade. You can tell it's sharp. Um, so that's easy, right? You can tell when someone has a concealed weapon. But the problem is they're using these Terry stops to now say, oh, this person is carrying weed or carrying some type of drugs. And it's like there's no way of accurately detecting whether that thing that's in their pocket that feels soft is weed as opposed to being this. So that's weird. Don't agree with that. So guess what law enforcement is doing? Do you think they're doing it the right way? No, they're using that. They're using these loopholes to now give themselves more room to do what they want to do. So also with motor vehicles, when the cops pull you over and have you get out of the car, that is essentially a Terry stop. So just remember that. So we're going to learn more about automobiles and how there's not a lot of Fourth Amendment protection in a automobile, and you're going to learn that in the future. We're going to talk about it in future cases. But that concludes chapter 4. We'll talk more about stop and frisk. I'm sure you can tell by my tone, and that I have a bad opinion of the Terry case. That Terry case is getting people killed. Um, it's allowing officers to now just come up to you and say, "Hey, we got a question for you." And this happens to some people, and when people say, "No, I don't want to be questioned," uh, then the officers can get attitudes, and now they can physically put hands on you. Now people are getting roughed up because they're trying to go to work or go to their cousin's house. They're walking, and they don't want to be bothered. So the Terry stop essentially took away our ability to not be bothered by cops. They can now stop us and kind of do what they want to do. They can pat us down, and these pat downs turn into running of pockets. I'm sorry. So uh, Terry's case was kind of a disappointing moment in Supreme Court history. I believe it is. Some people agree that it was fine, but fast forward to 2019. Look at what we're seeing in all these encounters with police officers where people are dying. So a lot of that stuff is based upon the Terry case. If the Terry case didn't allow them to bother us or bother people that are walking down the street, then a lot of this stuff wouldn't be happening. So you got to think of it that way. So if there was no Terry case, police officers couldn't bother you unless you were in the commission of a crime and there was probable cause, a very high standard. But now they can almost stop you as they please and say, "Hey, what are you doing over there?" It's like, minding my business. What are you doing? At that point, they can now frisk you and interrupt your day. And honestly, as a police officer, being in law enforcement, they can give you a charge. They walk around with a license to ruin your life, not only take your life because they have a gun, but if you rough me up and then as a part of rough me up or using force, you're going to try to justify it by saying I use force, then that means you're going to charge me. And I didn't commit a crime. I was walking down the street minding my business. Now, um, I was walking around with someone that's never been in trouble before in my life and minding my own business. Now I got a court date. So that is essentially a license to ruin people's lives. So I think with great what do I say? Trying to think of the word. I guess with great power comes great responsibility, and I think we've given law enforcement a lot of power, but in the case law, we're taking away more and more of their responsibility to be responsible with that power. But that's just my opinion. You're not going to get graded on my opinion. You don't have to see it my way. As a matter of fact, if you don't, please voice your opinion. Okay, I actually am cool with law enforcement. I believe they're needed, but I don't necessarily agree with a lot of the leeway they're given, because the one thing that's required of a law enforcement officer is you must be a human, and a requirement of a human is you must be imperfect. So we're giving this unlimited power to imperfect people. So it's kind of scary. So that ends chapter 4 on stop and frisk. Of course, our next lecture is going to be on chapter 5. So you guys take care and have a good day.